Welcome, everybody. We're going to get started in just a second as folks are filtering in. Thank you for being here. For those of you just joining, we're about to get started. I just know there's a lot of folks in the waiting room who are filtering in, so we just want to give them a minute to join us. Thanks for being here. Okay, we're going to go ahead and get started. Thank you so much for being here today for the IIP's monthly webinar. My name is Rachel Marshall. I'm the Executive Director of the Institute for Innovation and Prosecution at John Jay College. The IIP provides a national platform to bring together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. We champion criminal justice reform policies that advance community-centered standards of safety, fairness, and dignity. We are delighted to be hosting today's event on the intersection of criminal and immigration law. And sadly, this is an issue that's probably more important than it ever has been, as a new administration is threatening to ramp up immigration enforcement and deportations. And so we know that it's really more important than ever that prosecutors understand the intersection of criminal and immigration law so they can make decisions that are just and well-informed in each case. And we know that protecting immigrant rights is also a key part of promoting public safety and trust in the justice system. So we bring today's webinar as the first in several that we're going to be offering over the next few months about immigration issues for prosecutors. So thank you for being here and recognizing the importance of this issue. Today's webinar is going to be sort of an introduction to what we often call crimmigration or crim-im, which is the intersection of criminal and immigration law. And we're going to be exploring the ways in which the criminal justice system can improve its treatment of immigrants, whether as crime victims or as accused. We'll be asking questions like, how does a criminal arrest, conviction, or even detention impact a non-citizen's immigration status? How does criminal law differ from immigration law in categorizing the severity of specific crimes? How can non-convictions even impact immigrants? And how are immigrants who face criminal charges, convictions, or contact with the legal system doubly punished? And we'll get into what that term means as a result. How can immigration consequences, most importantly, be minimized by the criminal legal system? And how can prosecutors seek to hold someone accountable without impacting their immigration status or immigration proceedings? We're also going to get through some relevant terminology that prosecutors should understand regarding immigration, and we'll walk you through a little bit about how immigration court proceedings work. I wanted to note before we get started that one of our presenters today, Linus Chan, our professor from University of Minnesota Law School, will be focusing a lot on Minnesota law, as we have a lot of folks from Minnesota, from the Minneapolis and St. Paul regions with us today, and we are offering MCLE credits in the state of Minnesota. If you are seeking MCLE credits, there's going to be a sign-in in the chat. I see it was just dropped, so please make sure you sign in so that you can get that credit. I'm going to introduce our panelists very quickly. And we will also be including a link to their full bio in the chat so you can read more about them. They have a lot of tremendous experience and accomplishments in this area. First, I'm delighted to introduce Talia Peleg, who's an associate professor of law and the co-director of the Immigrant and Non-Citizen Rights Clinics at CUNY School of Law. She and her students represent non-citizens in all aspects of the immigration system. Her scholarship and practice focus on combating the entanglement of the immigration and criminal legal system. And prior to teaching at CUNY, she was a supervising attorney in the immigration practice at Brooklyn Defender Services. Welcome, Professor Peleg. Next, we're delighted to have Abel Rodriguez, who's an assistant professor of law at St. John University School of Law, where he teaches criminal law, immigration law, and crimmigration. His research focuses on race, migration, and the intersection of criminal and immigration law. And prior to entering academia, Professor Rodriguez was the immigration specialist at the Defender Association and a staff attorney at Nationality Service Center in Philadelphia, where he specialized in deportation defense for the formerly convicted. Welcome, Professor Rodriguez. Next, we have, as I mentioned, Professor Linus Chan, who's the James H. Binger Clinical Professor of Law at the University of Minnesota Law School. He is an associate professor and the director of the Detainee Rights Clinic, and he's an immigration attorney who focuses on removal defense for those detained by immigrations and custom enforcement. He also teaches in the area of intersection of criminal and immigration law. Welcome, Professor Chan. We're delighted to have you here. And last but certainly not least, we are so honored to have with us Professor Ingrid Eagley, who's a professor of law and faculty co-director of the Criminal Justice Program at UCLA Law School. And her teaching and research interests include immigration law, criminal law, evidence, and public interest lawyering. Professor Eagley is an expert in the intersection between immigration enforcement and the criminal legal system, and her recent work explores a range of topics, including the prosecution of immigration crimes, the role of public defenders and U.S. immigration courts. So we have, as you can see, a number of really esteemed experts with us today. And in light of that, we're going to do things a little differently for those of you who are used to a lot of IIP webinars where they're all discussion focused. Today, we're actually going to give each presenter an opportunity to have some time to share with you some of their expertise and give some guidance for prosecutors in these areas. Each presenter will have roughly 15 minutes to talk, and then I will have a few questions for some moderated discussion. But most importantly, we'll then at the end have an opportunity for all of the questions that you all have. And we really want to make sure to get to as many as possible. Throughout the presentations, please put your questions in the chat, or I'm sorry, in the Q&A button. We will get to them at the end of the presentation. So please keep them coming throughout and we'll make sure to return to them. So without further ado, I'm going to turn it over to Professor Peleg to start our presentations. Thank you all.
Okay, great. So I will go ahead and share our slides. If you'll just give me a moment, please. And so I'll multitask while I'm doing that. I will just say thank you to all of the wonderful folks at IIP for putting this together and for everybody who's joining us. Thank you so much. Okay, and there we go. Okay. Can folks see my slides? Yes? Okay, excellent. So Talia and I will start by just giving some really kind of foundational information about crimmigration and the crimmigration system. Really kind of broad strokes, just some fundamentals, and we'll kind of go back and forth as we go through our slides. So just a bit of a roadmap. I will start with kind of big picture, just an overview of the crimmigration system and crimmigration. Then we'll get into a little bit more nuts and bolts, some key terms and frameworks of the system. If we have time, we'll get into practical considerations of plea bargaining, sentencing, etc. And then questions, as Rachel mentioned, we'll save until the very end, until everyone has presented and there's been some discussion. And then at the end, there will be some time for Q&A. All right. So as I said, starting with just some broad strokes, the term crimmigration was really coined by Professor Juliet Stumpf in a law review article in 2006. And since then, much has been written, and that system has evolved considerably since that time. And scholars really point to the 1980s as kind of the inception point of the crimmigration system. Of course, there's been intersection and overlap between criminal law and policy and immigration law and policy that dates well before the 1980s. But many scholars have pointed to that as really being kind of the inception of this crimmigration system and this more robust kind of union between criminal law and policy and immigration law and policy. And as I said, since the 1980s, it has evolved and expanded considerably in that time. And so scholars have pointed to really three pillars of this crimmigration system. So first, increased criminal prosecutions for immigration offenses. And so at this point, about half of federal prosecutions are immigration related, and that's largely related to unauthorized entry and re-entry. That's the first pillar. Second pillar being expanded immigration consequences related to crimes. So in other words, more offenses triggering potential immigration consequences. And so an expansion of people facing, detention, deportation, inability to adjust their status because of contact with the criminal justice system, and because of convictions, although we'll also talk about possible consequences that stem from even arrests or admissions that are made to immigration officials. We'll talk a bit about that later. And then the third pillar being heightened collaboration between police and immigration officials. So things like 287G, which essentially deputizes police to act like immigration officials, secure communities, which facilitates information sharing between police and federal authorities. And so this really heightened collaboration and kind of sharing of like tactics between police and immigration officials. Okay. All right, so just a bit about crimmigration's consequences. Overall, study after study has shown immigrants do not raise crime rates, yet non-citizens within the criminal justice system face not only, all the consequences, collateral consequences of convictions, but in addition to that face, potential immigration detention and, of course, removal from the country and a host of other potential immigration consequences, which we'll get into a bit more. The crimmigration system fuels mass deportation and family separation. Hundreds of thousands of people are removed each year from the country, and many of those are are classified as being removed on criminal grounds, although many of those are very kind of low-level offenses. And it also perpetuates racialized enforcement, which I'll say a bit more about. So for instance, Professor Yolanda Vasquez has written about how Latina immigrants have been racialized as quote unquote criminal aliens. And so she points out that Latina immigrants are 44% of the total immigrant population, but 94% of criminal deportees. Professor Carla McAnders has written about how Black immigrants are 7 to 9% of the immigrant population over the past couple of decades, but are 20.3% of criminal deportees. And I've done research on how people have lost their lives within the enforcement system. And so, for instance, as I just mentioned, Black immigrants in the past couple of decades have been between 7 to 9% of the immigrant population, but for instance, are 30% of people who are losing their lives in detention. And Latina immigrants representing 44% of the immigrant population are 70% of those losing their lives in immigrant detention. About one person per month dies in immigrant detention. About two people a day die at the border. Yeah, in terms of detention, the average age of people dying in detention is 45, which is below the life expectancy of any country anywhere in the world. And so pointing to premature death within the detention system. Okay.
Great. I'll take it from there. Thank you. So we want to talk a little bit about how does this actually work in practice. So this is sort of a little bit of an outdated chart, but was created by an organization here in New York, where I'm based, just to really give you the visual of where ICE is coming into contact with the criminal legal system. And so you can see, right, as early as police stops, there are, and Abel spoke about some of the programs in which ICE, shares information and local officers share information with ICE. You see all the way from booking to plea and disposition, there can be contact with ICE, all the way through going sentencing to potential jail time. And there's different programs. And it's for this purposes of this, I think it's less important to understand all the nuances of that, but to say that at all stages of the criminal proceeding, and really at all stages of, prosecutor involvement, as many of you here are prosecutors, there is potential for detection and enforcement. And that's why it's so important to understand these dynamics. And this chart is to say nothing of what Abel mentioned about 287G, where localized enforcement are deputized under the Immigration and Nationality Act, which the incoming administration has said they're really seeking to expand that. Historically, it was larger than it is now, but also there's also jurisdictions such as Texas, which has proposed SB4, which is currently not in effect. It's on review before the courts. However, that would sort of allow for local officers under state law to enforce immigration law. So there's that and other copycat statutes that are even seeking to broaden this enforcement through using local officers. So this, again, is just guidance. It depends where you are in the country, which policies are in effect, but important to know. And there is a direction towards more local enforcement. But also at the same time, there are states like here in New York where there might be some sanctuary provisions in place, or, to try to limit the information sharing, try to limit the collaboration like we have here in New York City and New York State. For example, there is a New York out of courts statute that doesn't allow for ICE arrest within or near the courts, in and on the way. So that's important to know, that you may have some differences depending on your jurisdiction. But this is really how ICE gets the majority of individuals that they seek for deportation, as we just heard, and sort of those staggering statistics, is through use of the local criminal legal system. So I'm sure all of you are familiar with the Padilla v. Kentucky decision that came out in 2010, where the Supreme Court finally held that non-citizens, immigrants, have a constitutional right under the Sixth Amendment to understand the clear risks of deportation associated with criminal conviction. And while that doesn't seem maybe, it was quite groundbreaking in 2010 to finally have the Supreme Court say that. And key to that court's decision was that immigration ramifications are really ingrained and embedded as part of the criminal case. And in fact, it's not really something collateral like had been used previously, in that it was really something that is so interrelated and so severe that we need to see the two as related. So if you don't mind hitting the next slide, Abel.
Sure.
Thank you. Um,
So there's a
so
slight delay, but it'll change. There we go.
No problem. Thank you. So that is clearly established in the Supreme Court, Padilla v. Kentucky. But what does this sort of mean for local prosecutors' duties, right? So, I wrote an article that's cited at the end of our materials, Abel and my materials, that you can look at more deeply, but sort of looking through what is the duty of the prosecutor when it comes to immigration ramifications. But I wanted to highlight a couple points from that just for purposes. We don't have a lot of time, but feel free to look at the article. I'm happy to speak to anyone offline further. But I do think at a minimum, there is a duty for prosecutors to understand this deep entwinement between the criminal legal system and the immigration system and these very severe consequences we're going to talk about today, but also to understand your roles as gatekeepers directly controlling this pipeline. And that's because the immigration laws refer to local laws and local criminal statutes as a mechanism, as a vehicle to deport people from the United States. So really what happens in the local court and in the local system is in fact fueling and deciding who is priority for deportation. And I'm going to talk about a little, and we'll talk about this more in Q&A too, but I think there is an obligation to take actions that account for the unique concerns and fairness considerations to avoid these outsized punishments for immigrant defendants. I want to say before we move on, very importantly, this does not supplant the defense attorney's duty under Padilla to provide sufficient, adequate advice and counsel to non-citizen clients about the ramifications and consequences of their criminal cases. That is absolutely the duty of the defense attorney. So prosecutors are not under this scheme, engaged in sort of individualized assessment and trying to provide specific advice necessarily to the defendant. However, taking these considerations into account in shaping policy and figuring out how to move forward with certain matters is still extremely important. Next, please. So in the piece, I think there's roots to support sort of this duty that I'm suggesting in the ethical obligations and professional standards that govern prosecutorial conduct. Also, there's Supreme Court jurisprudence, both in Padilla, where Justice Kennedy is really sanctioning sort of this kind of informed consideration of why that's important and for prosecutors to do in these kinds of cases. And not to mention, sort of prosecutorial rhetoric around reform and seeking to sort of address some of the key injustices in the criminal legal system. That has been rooted in reform, that many of those same considerations apply to those immigrants that are being targeted under these systems, who often tend to be immigrants of color, as we heard before. Next slide, please. So often we get this question, and many of you may have it yourselves, of, is this really, is considering immigration consequences somehow favoring non-citizens over citizens? And I'm going to just read a quick quote from Dan Sattenberg, who's the former attorney in King County in Seattle, who said, quote, "There's certainly a line of argument that says, no, we're not going to consider all of your individual circumstances. We want to treat everybody the same. But more and more, my eyes are open that treating people the same means that there isn't a life sentence of deportation that might accompany this conviction." And so I think that really says it well. So in other words, I think not considering the immigration consequences or deportation, which, has been equated with exile, and for many individuals might be more severe than even imprisonment, is actually kind of unequal. So considering the proportionality, the extent of all of the ramifications of a contact in the criminal legal system is in fact, more equitable and more rooted in equality and sort of equal treatment than sort of not, or treating everyone blanketly the same. Next slide. Go ahead.
Okay. So I'll just say, just very briefly, like I said, just broad strokes here, a bit about different immigration statuses. and some considerations, here at the intersection of criminal and immigration law. One, just keep in mind that status is fluid, that people may move through kind of different statuses. Maybe either, begin undocumented and then be able to adjust status, or enter on a temporary visa and be able to adjust their status and become a permanent resident. And so we'll talk a little bit about those different statuses, but just very briefly. But that there is a very broad spectrum, and I have a couple of visuals for that as well. So let's begin there. And so you can see the range of statuses, the kind of statuses that people are more familiar with may be lawful permanent resident or green card holders. So people who can generally remain here indefinitely, although they are still subject to the deportability grounds and removal proceedings, including on criminal grounds for particular convictions, asylees and refugees, folks who are here on temporary visas, and folks who are undocumented. And so within this work, those are the kind of more common statuses that we see people in as we're considering immigration consequences. But there obviously are other statuses as well. And so, for instance, folks who are on DACA, deferred action for childhood arrivals, folks who have temporary protected status, et cetera, et cetera. And each of these statuses may need to be considered, or often need to be considered differently in terms of potential immigration consequences and what sorts of offenses can trigger consequences for people in those particular statuses. But it is a broad spectrum. In fact, if we include all of the temporary visas, there are over 100 different kind of postures or statuses that people can be in. And as I said, each needs to be considered individually and uniquely. And then just to make the point that even people within the same status may need to be treated differently or considered differently. So for instance, you could have two people even charged with the same offense who are permanent residents, who, imagine somebody who was admitted, 4 years ago as a permanent resident and somebody who was admitted 6 years ago as a permanent resident. The analysis may be different for each of them, even though they have the same status, right? They're both permanent residents and could potentially remain here indefinitely if the immigration consequences can be avoided. The analysis may be different for each of them, just as an example. Just the other thing that I'll say is I do not mean to speak for all non-citizens by any means, but just in my own experience and practice, the public defenders that I worked with, in speaking with colleagues, is that immigration consequences are very often the most important concern for non-citizens who are charged with criminal offenses. So like I said, not to speak for everyone, but many times that is the primary concern for folks who are charged with offenses. Okay. All right. So we'll talk about some key crimmigration terms. I'll go through this fairly quickly, especially because Linus is going to talk a bit about convictions, the definition of a conviction under immigration law, how diversion programs fit into how a conviction is defined. So I won't say too much there. I'll kind of skip over that. And then in terms of crime categories at the end of the list, Dalia is going to say a bit about that. So I won't say too much here. She'll go into some of these different categories that can trigger immigration consequences, like crimes involving moral turpitude, controlled substances, aggravated felonies. So she'll say a bit more about that. So I guess I'll focus a bit more on detention. And so focus on the fact that within immigration, there is mandatory detention, which may be triggered by criminal convictions, by contact with the criminal justice system. And what that means is that someone who is placed in removal proceedings may be detained, placed in an immigration detention center, and have no opportunity for a bond hearing or to bond out of immigration. And so they will be in detention for the duration of their removal proceedings, which may be months, could potentially be years, but they would remain in detention during that time. Discretionary detention means that the person may be able to avail themselves of a bond hearing and of bond. Yeah, just that detention centers, many of them are housed within jails and prisons around the country. At this point, I believe it's at least 80% of people who are in detention are in private detention facilities. I imagine many of you are familiar with some of these other terms, detainers, which are essentially a request from ICE, from Immigration and Customs Enforcement, for jails or prisons to hold people for 48 hours in order to be transferred into immigration detention or immigration custody. Writs can often be important for folks who are looking to resolve their criminal proceedings. And so in order to bring people back to their criminal proceedings, non-citizens may desire that in order to, for instance, in order to be able to seek relief from removal before an immigration judge, they may wish to return to resolve their criminal proceedings in order to seek that relief in immigration court. And then in absentia removal orders, just that for people who do not appear for their immigration proceedings, that immigration judges can and do order non-citizens removed in their absence if they are not present at the removal proceedings. So that's just a broad overview of some terms and a bit about detention. And then, as I said, Dalia will go a bit more into the different categories of crimes.
Great. So what are the consequences of criminal context? So deportability, as Abel said, really applies to people who are green card holders or here in lawful, had some sort of admission, so generally visa holders. And usually, in order for a criminal contact to trigger that ground to place someone in deportation proceedings, there needs to be a conviction, which we'll hear more about from Linus, but broadly, just important to keep in mind for now that conviction is defined much more broadly under immigration law than it is in most local jurisdictions. But it requires sort of a formal conviction in order to trigger deportability for someone who's been admitted. Versus inadmissibility, where conviction is there, but also admission could be enough. So an example is controlled substance offenses, very broadly, admission to something, a controlled substance offense, could be enough to try to render someone inadmissible, which essentially would block them from getting a green card, from getting a visa. This is someone who's, trying to seek a new status or very often trying to seek a green card. So the ramifications are broader of criminal context for someone who is concerned with inadmissibility. Next slide. So this is a chart that the Immigrant Defense Project has. It's terrific. Really, I recommend everyone has it. It's on my desk. It's been on my desk. Everyone I know who works in this field has it. You'll see the middle column. It's hard to see, it's small, but the middle column has a sort of summary of the deportability grounds, the criminal deportability grounds, and on the top left, you'll see a summary of the inadmissibility grounds. So you'll see some overlap in terms, but what makes this so complicated, in addition to what Abel said about all the different statuses and the timing and all of these things, why this is so complex, is the same kind of offense may have different rules rendering someone ineligible for a green card versus someone who's a green card holder, subjecting them to deportation. So next slide. We don't expect you to walk away with all of these, but want to give you just a nice little sense of sort of this overlap, but kind of complexity. So you'll see on the left, you'll see in all three columns. So the left are grounds that make someone inadmissible, the middle deportable, and then we wanted to show some of the criminal barriers to naturalization, which is becoming a US citizen, for those of you who don't know. And there's some overlap, you'll see, right? But they're different. So for example, a controlled substance offense, right? Even in a jurisdiction where that might in fact be legal, right? Many jurisdictions have decriminalized the use of marijuana. You see under deportability, controlled substance offense would make someone deportable and inadmissible, but there's an exception under deportability for a single offense, possession offense of 30 grams or less. So that's why many of you I know who are working on the field might, have someone tell you that a client, a green card holder, may be able to plead guilty to a possession offense in one circumstance, but not the other, because it would not render them deportable under these very convoluted rules. So this is a long category list but just giving you a sense of sort of the nuance and differences. Next, please. So I just wanted to oh, actually, this is you, Evel. Go ahead.
Oh, is it? Oh, okay.
Yep.
And so yeah, so just some of the categories that you just saw on the previous slides. Good? Yeah. We'll just break these down a little bit for you. Again, broad strokes. But one that you may have noticed is CIMT, or crimes involving moral turpitude. And that is really kind of ubiquitous throughout the INA, throughout the Immigration and Nationality Act. And you just kind of see it in all of these different categories, right? It can trigger deportability, can trigger inadmissibility, can trigger good moral character issues for folks. So this has been defined, there's no statutory definition. And so courts have defined this as conduct that is base, vile, or depraved. Essentially, this really acts as kind of a catch-all that includes many minor offenses, including, for instance, petty theft. And so often the analysis the courts are doing is there some scienter, is there intent? But even, for instance, offenses that are committed with recklessly can trigger CIMTs as well. Yeah, especially if there's kind of some aggravating factor. So think like, an assault where there's great bodily injury, right? Or serious bodily injury instead of simply bodily injury, as an example. Then recklessness may trigger a CIMT as well. Controlled substance offense includes most drug offenses, although I think Linus is going to talk a little bit more about some specifics about controlled substance offenses, so he'll get into that. And this can include marijuana, even potentially if obtained legally. Okay. Domestic deportation grounds, crime of domestic violence, crime of stalking, child abuse, abandonment, neglect, and violators of protection orders are other categories that can trigger consequences as well. And we'll talk a little bit more about this very briefly about the analysis of how courts determine whether an offense may trigger these federal categories.
And I'll jump in here with aggravated felonies. We don't have much time, so very quickly, this is a term of art used in the INA. Really important for everyone to understand that these offenses that fall into this category do not have to be particularly aggravated and do not need to be felonies at all, despite the term. It's a ground of deportability, so it applies to most often the green card holders, people have been admitted, but the consequences are really severe. Deportation is a near certainty. Permanent ineligibility for naturalization, for example, triggers mandatory detention without bond in these prison conditions, a permanent bar from coming back, and potential enhancement. So really important when you're looking at this, when someone talks about an aggravated felony, these are the consequences that attach. Next.
Okay. And so just a bit about plea bargaining and sentencing. So one is that non-citizens may be seeking alternative offenses if they're considering pleading. So for instance, that may be an offense that was charged. So potentially pleading to very specific offenses that were charged in order to avoid the consequences of other offenses that were charged. But it also may mean pleading to alternative offenses altogether. So in practice, we would sometimes ask if it would be possible to avoid a charge altogether, and sometimes this meant fictional pleas, right? So it may be that a drug possession charge is now changed to disorderly conduct, and the non-citizen is willing to plead to that offense, but the drug possession charge would trigger controlled substance, immigration consequence, which may mean deportability for them. So it may mean considering different offenses in order to avoid the immigration consequences. Here's where I'm saying we won't get into the categorical approach in depth in any way, because we could spend the entire hour and a half just talking about that and just kind of scratch the surface about what the categorical approach is and how, for instance, immigration judges do this analysis as to whether a criminal offense triggers one of these immigration categories and immigration consequences. So just very briefly, I'll say that generally speaking, immigration judges look to the criminal statute itself, and the facts are generally irrelevant to the analysis. That's a categorical approach, but there are instances in which, and this is pretty complicated in terms of when judges can look beyond the statute itself and look to the record of conviction. And so the record of conviction can include the charging document, plea agreement, transcript, jury instructions, etc. And so there are instances in which immigration judges in doing this analysis can look behind the criminal statute itself and look to the record of conviction. And so it may be that a non-citizen and defense counsel are asking for specific things, either to be put on the record or for the record to be left vague. And often that depends on kind of who has the burden in immigration court. If the burden is on the non-citizen, then they may ask that specific information be put on the record. And so that may be, can we specify recklessness for this offense and put that on the record? Can we, reduce the amount of marijuana in order for it to fit into that small amount of marijuana exception that I briefly mentioned, for example? Or it may be that if the burden is not on the non-citizen, for example, that leaving the record vague may be sufficient to mitigate the immigration consequences. So, for instance, not mentioning mental state on the record, if that's possible, not mentioning a domestic relationship on the record, if that's possible, the type of firearm, etc. Things that non-citizens and their defense counsel may also ask is for some consideration in terms of sentencing. And so, as we mentioned, for instance, aggravated felonies, some are sentence driven, meaning that if a sentence of a year or more is imposed on that particular offense, then it will trigger the aggravated felony category under immigration law, which, as you saw, has many very serious consequences. And so one way, for instance, to avoid those sentence-driven aggravated felonies is to, for instance, stacking sentences, right? So just as one example, if it's a potential sentence of a year, jail or house arrest, considering a sentence of 364 days would avoid that sentence-driven aggravated felony and all the consequences that stem from that conviction. Or for instance, like I said, stacking sentences. So imagine, a possible sentence of 10 months to 22 months. That rather than having a burglary offense with a sentence of jail or house arrest of 10 to 22 months, stacking that and having consecutive sentences of 5 to 11 months on burglary and then another offense, for instance, criminal mischief. That would avoid the aggravated felony because there is not a sentence of a year or more on any one of those offenses that could potentially trigger an aggravated felony, which burglary often does. Theft offenses and burglary offenses. Okay.
Great. So just as I was saying, the definition of conviction is extremely broad. Post-conviction considerations, as people approach you to consider potential post-conviction relief, it's important to keep in mind that the Board of Immigration Appeals has a very narrow definition of when post-conviction remedies will be recognized. Vacating conviction is or sentence will only be valid under the immigration law if it's based on a procedural or substantive defect in the criminal proceeding, which has generally come down to a constitutional defect in the underlying proceeding, usually an ineffective assistance of counsel claim under Padilla, that's often. And here are the two cases and authorities for that. So that means, unfortunately, many of the clean slate initiatives that are growing throughout the country, many of you may be involved in, if it's not the expungement or the sealing of the record alone is not enough. It must be done for a substantive or procedural defect in the underlying proceeding. So rehabilitative statutes or simply sealing without sort of that reasoning will not be recognized by the immigration court. So it really creates this kind of crazy situation where there are people who have convictions that have been expunged, by the convicting jurisdiction, still retain the conviction on the federal side in immigration. And PCR, sort of for these misadvisals, like I was talking about, or failure to advise under Padilla, often can take, if someone is detained in immigration and facing proceedings, those cases might go very, very quickly and might go quicker than the PCR process. So it was really important to try to expedite that if at all possible, if you are considering assisting in a PCR matter.
And I think that's our time. So I think we'll transition from there. I'll stop sharing my slides.
All right. Thanks, everyone. Thank you, Talia and Abel. And first of all, I want to thank IAP for having me to talk a little bit about this. Now, I do have some slides, but I want to wait to share them in a little bit because I want to provide a little bit of context to what I'm going to be talking about, which is the definition of conviction. Now, at one point, it might seem a bit odd about why we're talking about what is a conviction for immigration purposes. And for a long time in immigration law, so just to give context, 1917 was the first immigration statute that established that people can be deported for having committed crimes after they came into the United States. There had been long time provisions that prevented people who were convicted of crimes in their home countries from coming in. But 1917, which is a relatively recent period of time, was the first statute that said, hey, if you were convicted of a crime after you came in, we can now deport you. Now, from 1917 all the way until the 1990s, there was not a congressional definition of what a conviction was for purposes of deportation. Why? Well, perhaps there was the assumption that the definition of conviction would depend on what state you're coming from. Perhaps there was a lot of, it wasn't a very explored area about figuring out what that was happening. And one reason for that was because it wasn't until the 1940s, until the 1960s, there was a big criminal justice reform movement that was trying to figure out different ways to encourage rehabilitation. And there were two primary ways of trying to think about encouraging rehabilitation. One, which was what we might know as expungement, right, is the idea that if you, after you've been convicted of a crime and you were sentenced and you did whatever punishment that was, if you continue to show yourself to be a good member of the community and show good rehabilitation, you then have the ability to get that conviction off of your record and have it expunged. It was a way to encourage rehabilitation. Then different states, and I'm happy to say Minnesota was one of the first states to really start with some of these reforms. Other reforms were on the order of, well, why don't we go ahead and allow someone not have to wait all that time to get a conviction expunged? We could charge someone with a crime. They admit to, what's called kind of deferred adjudication or stays and say, hey, as long as they remain good during a certain period of time, we could then get rid of the conviction later on because we would have over them the prospect of a conviction, but it again encourages people to not go ahead and worry too much and get and encourage rehabilitation. And that movement was in the 40s and 60s. And what you started to see was the immigration courts were having a hard time figuring out what to do with people's convictions that were often being bandied about, whether they were being opened, reopened, put on file, or not. And there was a case that went up to the Supreme Court in 1955 called Pino versus Langren. And it's a fascinating case because the actual uh, uh, con, court decision has essentially 3 sentences. And all it says is, based on the record, we don't believe this is a final conviction. And what had happened in that case was a Massachusetts conviction was going up and down, was being put on file, and it had a version of it being kind of held in stasis. So what you started to see post during that period, and why Abel was talking about the 1980s as being one of the big areas of movement in immigration law, was there was an increasing backlash to this idea of rehabilitation. And in that context, there was an increasing backlash to the idea that non-citizens could avoid deportation because state courts and state processes allowed their convictions to be vacated, expunged, or stayed in that process. And so what came out of that was there was a Board of Immigration Appeals decision that tried to limit the impact of that. And then finally in the 1990s, there was Congress put in the word and gave an actual restriction on the use of that. I'm going to go ahead and start sharing some slides. All right. Okay. So now I'm going to talk a little bit about specific Minnesota law about how Minnesota defines convictions, how it does stays, and how that could impact a person's immigration eligibility for deportation in the future. All right. So as I mentioned, Congress didn't get around to creating a statutory definition of a conviction until quite late in the game, and this is the definition they came up with. This is something that Abel kind of threw up there for a little bit, and I want everyone to sort of focus on a couple of key elements here. One, there is the idea that it has to be a formal judgment of guilt by the alien entered by a court. So that's the normal course of a plea or a jury verdict, right? That's the formal judgment part of it. But then the statute says, or if the adjudication of guilt has been withheld, where a judge or jury has found, and use the word alien because that's the statutory term here, guilty, or the alien has entered a plea of guilty or nolla contendere, and this is important, or admitted sufficient facts to warrant a finding of guilt. So there are 3 distinct ways that guilt is established. One, a formal plea or a formal jury verdict or judge-based verdict. Second, a nolla contendere plea can also be sufficient to find guilt. And third, any admission of facts to warrant a finding of guilt. And then the other really important term to pay attention to is as long as some form of punishment, penalty, or restraint on a person's liberty to be imposed. Now, it's an or clause. So a financial penalty, a fine, is also enough to trigger a finding of a criminal conviction for purposes of the immigration statute. So obviously that counts for imprisonment, but it can also count for certain forms of probation. And in Minnesota, that could be an assignment to a workhouse. It could be all different ways that the state has tried to come up with alternative forms other than actual imprisonment to the Department of Corrections. All right. So I'm going to talk a little bit about the first one of the more common ways that in Minnesota a person can avoid getting a criminal conviction after being charged with a crime. And that is through a process called a stay of adjudication. Now, the 1996 Supreme Court decision, which is called State versus Kreutzer, I understand that first sort of dealt with the challenge of whether or not courts actually had judicial authority to withhold an adjudication of guilt. That, of course, decision has been overturned on a number of different bases, but the stay of adjudication itself is located in the Minnesota statute 609.095 as sort of an examples of when it cannot happen, but it is recognizing the authority, especially with the agreement of both the prosecutor's office as well as the defense on what a stay of adjudication could be. Now, it has to be upon agreement. That's one. And the second is there must be some allocution to a guilty plea or finding of guilt in order for the adjudication to be stayed. So right away, when we go back and think about what this means, we realize that this, at the point of a withheld adjudication of guilt, still qualifies as a conviction. This is a confusing thing that is often happens to people that I see by the time they go in immigration court. They have been told, either by their attorney or by the court, that if they complete the requirements for a stay of adjudication, and stay of adjudication can involve, they can involve time in jail, time served. It can involve any sort of, drug testing, drug counseling, or any other forms of ways to get people into a rehabilitative state. Nonetheless, people come in immigration detention and say, wait a minute, I did everything. I was told that the adjudication is no longer, I completed what I needed to do. I no longer have a conviction for purposes of state law. And that's true. But for immigration, what that means is it's still a conviction under immigration law. And so they take that as a conviction. Now, one question is, well, sometimes, right, as was mentioned, certain criminal grounds of deportation may require certain sentences. Okay. In that context, it depends on what actually was pronounced with the stay of adjudication. Most often, there are no sentence pronounced. There might just be probation conditions, including jail time. So that could avoid still the idea of getting a criminal ground of removal that requires a 1 year or more sentence because no sentence was actually pronounced. However, it's still enough to trigger because there are these restraints on liberty or are these conditions that a person has to go through in order to avoid a final adjudication of their guilt. Now, there are other programs. And so one other kind of tool that I've seen that can be effective is under a Minnesota statute, which is 609.132, which is the ability for the prosecutor to have lodged a criminal complaint or a criminal charge against someone, but then ask the court for a continuance for dismissal. And the idea here is the prosecutor is basically saying, we are going to keep the charge pending, but as long as this person essentially doesn't get into any other problems or issues, we will then dismiss this case at the end of whatever period the continuance would be for. Now, that avoids a conviction for immigration purposes as long as there is no admission of sufficient facts. Now, the really interesting aspect of a continuance for dismissal is that often there are some conditions of release or other conditions that kind of are an agreement between the prosecutor and the defense in order to get the continuance for dismissal. So there could be something that may satisfy that second prong of the definition in terms of restraint on liberty. But as long as there is no admission of essential facts, then that can avoid a actual immigration conviction for immigration purposes. You see this sometimes happening. There used to be, or there is, I think it depends on the certain state, um, programs for drug diversion or drug school. A lot of the drug diversion and drug school work under a stay of adjudication model. First time offender comes in, admits guilt, and then the court stays adjudication of their case. Then they're allowed to complete drug programming. But there was, for a while, there was the existence of sometimes trying to get allowance to go into drug diversion without that first admission. And at least in certain situations, I know I've heard about where what essentially happens, though, is that the prosecutor's office, they still want the ability to hold the ability to prosecute that person in the future in order to encourage rehabilitation. So there have been situations where a criminal defendant may sign an affidavit which may admit facts that would allow for prosecution that the prosecuting attorney would hold and not enter it into the court record, presumably so that the prosecutor has the ability to get an easier conviction if the person doesn't follow through with drug school or other rehabilitative efforts. I think that is an area that is a bit dicey. There have been aspects where immigration officials, both USCIS and others, may request information and any documents that might involved in that criminal proceeding, which may include any affidavits with an admission of guilt. Now, personally, I think the statute still requires it to be part of the record and an adjudication in open court. But nonetheless, that is one interpretation that could at least confuse efforts in order to avoid the substantive conviction aspects of it. Now, Abel mentioned a bit about sentences, and sentences are really, of course, important because one, you can have what's called a crime involving moral turpitude that was committed within 5 years of admission that has a potential maximum sentence of 1 year or more. That could lead to deportation. And of course, there are several different aggravated felony provisions, such as a crime of violence provision and other offenses that have a 1 year or more. And it's important that immigration law, federal statute, again tries to define what is meant by a sentence. So again, the efforts here are to prevent the idea of having a suspended or any sort of ability to use a sentence hanging over someone for rehabilitative purposes. So the immigration statute that I'm saying here basically says as long as a sentence is pronounced by a court, it is considered to be the operative sentence, even if there is a suspension of imposition or suspension of execution. And this again is confusing for quite a few people who end up in immigration detention. You ask them, well, what did you get sentenced? And they'll say, I was, sentenced to 90 days in county jail or time served, or I would have had other sentences, not necessarily realizing that they had a suspended sentence that was issued over them, that as long as they complied with the other probation and other restrictions, that pronounced sentence would never be executed and they would never spend a day in prison. But for immigration purposes, it doesn't matter. So in Minnesota, this is sort of the definition of what a stayed sentence is under the state law. And here are, the two different types of stays that are most used. One is what's called a stay of imposition. And the idea here is you get a felony sentence, but you get a stay of imposition, or excuse me, you don't get it. You have a felony conviction, but you don't have a pronounced prison sentence or an imposition of that sentence, and after you comply with those requirements, then the conviction is then deemed to be a misdemeanor under Minnesota law. It's still included in criminal history. It's still a conviction, but it's not a felony under Minnesota law. While a stay of execution, there is an actual pronounced sentence, but it's not executed, meaning the person is never turned over to the Department of Corrections. Now, nonetheless, even if they complete all the requirements of the stay of execution, they would still have a felony conviction, and it would show up under the criminal history that way, but they would not actually have served any time of incarceration under that felony sentence. So again, this could lead to some really interesting problems here in terms of, as I mentioned before, immigration law cares about what a maximum sentence is. Now, sometimes it cares about what the pronounced sentence is. It's important that none of the ways that try to encourage compliance with, rehabilitation, that is not going to be accepted under immigration court or immigration law. So one provision that I think is really important is that other programs that states use to encourage rehabilitation can include anything from workhouse release, which is one thing that is common here in Minneapolis, maybe other sorts of work release programs. There's what's called the challenge program here in Minnesota. They all have these provisions which sort of allow someone to serve a different type of punishment other than incarceration. The issue here, of course, is that under immigration law, as soon as there's a conviction and a sentence pronounced, the immigration officials can execute removal unless a person is continuing to serve a term of imprisonment. So, just to give an example, if the court sentences me to 5 years of imprisonment under the Department of Corrections, and I am in the Department of Corrections facility, then this statute under immigration law, which is INA 241A14, basically says immigration officials do not remove that person from the United States until he finishes that sentence. However, if instead I get a stay of execution, right, for that same sentence, and the court or the judge wants to impose, or the Department of Corrections decides I'm a good candidate for the challenge program or any other program that allows for me to spend some time outside of the prison, well, that would be a situation in which the immigration officials can lodge an immigration detainer and then go ahead and arrest me as soon as I'm outside of prison walls and deport me. And what that means is a lot of times people who are non-citizens who are in immigration detention, especially if they've been lodged a detainer, will not get any access to any of those rehabilitative efforts because state officials know that they won't actually get to do them because immigration may come and deport them. And so that's a really, I think, an important aspect to kind of understand here. I had a client who had a plea bargain. This is back in the late 90s, early 2000s, had a plea bargain with the prosecutor. The prosecutor thought this person would be a great candidate for the challenge program. Everybody assumed that he was going to be in the challenge program. But when he got to the DOC, the whole story is he went ahead and packed a backpack and put a toothbrush in because he thought he was just going to be able to go into this release camp. And instead, he ended up having to serve his full pronounced sentence of 2 years in the DOC because the DOC was looking at him and say, look, if we release you to non-imprisonment, you might, immigration officials would just go ahead and pick you up and deport you, and that doesn't seem to be a good use of those type of programs. Okay, I'm going to really wrap things up and talk about post-conviction, appeals, and pardons. Okay, it's not in the statute. However, there's a general practice, and it's really confusing because some courts have made this ruling and other courts, it's unclear. So it's an area of law that might change. But it's generally understood that a criminal conviction that leads to deportation has to be final. What does finality mean? Finality, for the most part, for most jurisdictions, means that a person no longer has an appeal as a matter of right. So if a person goes ahead and enters a plea of guilty and waives their appeal, then that conviction is final. If, however, a person is, let's assume they enter a plea bargain but has reserved the right to appeal to challenge a specific issue, as long as it's to the first order appellate court, to the Minnesota Court of Appeals, then it would not necessarily be considered a final conviction. However, there's been quite a few discussion about what if a person has the ability to appeal to the Minnesota Supreme Court. Well, that's not considered an appeal as a matter of right, and so most jurisdictions consider that as not preserved, the conviction is still final for purposes of immigration. Now, there's the post-conviction process. I am most familiar with the post-conviction process here in Minnesota. I know that there are a couple of prosecutors that I've been working with and talking about this issue on post-conviction for some time. So there's just a couple of things that I will just touch upon in which I think prosecuting offices can have a lot of discretion about when it comes to post-conviction. Just about every state has what are called time bars to consider post-conviction forms of relief. In Minnesota, it's 2 years and until the time of the conviction is final. So that 2-year time bar, however, there's, in some situations, a prosecuting office could waive the time bar and allow a person's petition for post-conviction relief to go forward. Now, as mentioned by Talia, you cannot put in a post-conviction petition, hey, this person's really good now. Can you go ahead and vacate that former conviction? Or, hey, this person's about to get deported and he's got a family and he's really got a sad case, or he might face persecution in his home country. Can we reopen his conviction? Under Minnesota law, in fact, the post-conviction statute requires it to be substantive or procedural defect. But that is also the requirement under immigration law. It cannot be for rehabilitative purposes, and it cannot be to prevent immigration. There is a question about who has the burden. Right now, immigration law says that if you are filing to try to show that your conviction is no longer valid for immigration, and you are what's called a respondent, you're the person facing removal, the burden is on you. You need to show that a post-conviction grant was not done for immigration or rehabilitative purposes. So what does that mean? That means if the judge grants post-conviction but doesn't say why, right? Maybe there was an agreement between parties and the judge just signs it. That can be a barrier to having immigration courts recognize it. It could be an example of when filing briefings, what are the basis for you saying that the conviction needs to be vacated? As was already mentioned, specifically a lot of clean slate laws. So for instance, Minnesota passed legalization of marijuana. There are several vacator provisions in the marijuana legalization statute. And it is, I think there might be some arguments that they could be valid under immigration law, basically because some ways of casting legalization of marijuana as non-rehabilitative and not for immigration purposes. But that's a really untested area, and it's an area that is likely going to be very difficult. And it will lead to certain situations in which a person no longer has a conviction for state law, but they want to get post-conviction relief because it's still a conviction for immigration law. And that is a continuing issue. For instance, in Minnesota, the post-conviction statute has been held to not to apply to that stay of adjudication process that I mentioned before, because courts have said person no longer has a conviction, so we can't grant post-conviction relief. But for the person facing removal, it's still a conviction for purposes of immigration law and posing a problem. Last part, pardons are very, very useful in very many different ways. However, two main restrictions. One, it has to be unconditional. And second, pardons of certain crimes are not recognized by immigration law, and that includes pardons for drug crimes. Any drug crime is not going to be, even if it's pardoned by the state, it is still going to be considered a conviction for purposes of immigration. All right, so I sped through this. Happy to answer questions, and I really want to hear Ingrid speak, so I will stop.
Hi, everyone. I hope you can hear me. It's great to be here. I want to thank the Institute for Innovation in Prosecution for hosting us and for having this event. I want to talk a little bit about some of the topics that have been discussed already, but go into more detail in particular into how they apply to prosecutors' offices. So since, for over 100 years, the Supreme Court has not acknowledged that deportation is a very severe consequence. In fact, they've used language such as those on this slide, that it can result in a loss of all that makes life worth living, that it's a drastic measure, it's equivalent to banishment and exile. In addition to the punishment of deportation, researchers have found that citizenship status also serves as an important axis of inequality in sentencing by criminal court judges. And so I think we know about how, race or gender can serve as an axis of inequality. But research by sociologist Michael Light and also reports that have been done in the federal system by the U.S. Sentencing Commission have found that judges on average tend to sentence non-citizens more harshly than they sentence citizens, even for the same crimes and controlling for all different factors. The U.S. Supreme Court, as Talia talked about, in 2010 issued a landmark decision. I know some of you asked for the citation to this in the chat, Padilla versus Kentucky. And importantly, in the Padilla versus Kentucky decision, the court acknowledged in even stronger language that deportation is an integral part and sometimes the most important part of the criminal punishment that comes from a conviction. So we can no longer think of it post-Padilla as something that is merely collateral. As was already emphasized by Talia, this is a Sixth Amendment obligation. This was something that was really sort of surprising when the court reached its decision, that the obligation to advise on immigration consequences attaches to the Sixth Amendment, such that defense counsel has an affirmative obligation to provide affirmative and competent advice to their clients prior to entering any kind of guilty plea and prior to trial. And absent that advice, the non-citizen can bring a claim for ineffective assistance of counsel. So for all of you as prosecutors, this is a big problem, right? Because you want to be able to secure your guilty verdicts. And so Padilla needs to be complied with. Not only is Padilla important from the point of view of defense counsel, but Padilla also talks about this as something that is important to prosecutors. And we can see here in this language of the decision that the court specifically explained that engaging in negotiations around immigration and deportation consequences can benefit both the defendant as well as the state. And that by bringing those deportation consequences into the fold, the prosecution can be benefited by, for example, having quicker and easier guilty pleas and ensuring the administration of justice. The state of California, where I'm from, teaching at UCLA, has specifically acknowledged the U.S. Supreme Court's decision and codified it into our state law, obligating all prosecutors that they must consider the avoidance of adverse immigration consequences in reaching a resolution in a criminal case. And the support for this law is the Padilla decision, essentially saying prosecutors in the state of California must comply with Padilla. Some of the speakers have already talked about different ways in which prosecutors engage in these plea negotiations. You can do this through alternative plea agreements, which are, of course, you're familiar with on all cases with citizens. But here it's trying to find an immigration neutral result. And that could also include having an alternative sentencing outcome or one that is recommended to the court, because judges also have an important role to play here. And then different kinds of pre-plea treatments, may or may not be effective in the immigration context. So I've done some research on how different prosecutors' offices have tried to implement this Padilla obligation, and I think we can put that article will be shared with you. It's in the Texas Law Review in 2016, and a lot of what I've discussed there is still valid now. I'm going to share with you a few more recent policies that have been developed since the time I published the article. But what I discuss in the article is that in analyzing different prosecutors' policies, I really sort of see two different threads come out. And what I would encourage you to do is to look at the policies that we'll share in the materials and really think about the fair punishment approach. So the fair punishment approach is one that when prosecutors really consider deportation consequences as part of the overall punishment for the offense that needs to be weighed in plea negotiations, and that as part of your duty to do justice, you consider the severe sanction that deportation causes for the defendant. There's another approach that I see in some of the policies and sometimes in combination, and this is what I call an exacting a punishment approach. Here, the idea is sort of that if we're going to give you something by having you not be deported, we're going to require you to have a more severe punishment. I would counsel against those sorts of policies, and I think we've seen offices in these years since Padilla. Now we've had more than a decade since the Padilla decision. We've seen offices move away from that kind of approach. Just in the interest of time, I think we'll share these policies in the materials that are being shared with you. But this is just an example here of the fair punishment approach from the Philadelphia District Attorney's Office. And here you can see, a real acknowledgement of the Padilla decision and what the Padilla decision says, and that prosecutors need to consider how to neutralize or reduce the severity of these immigration consequences, and that to the extent possible, prosecutors in this office are being told by the head prosecutor that they need to consider immigration neutral outcomes in appropriate cases. In addition, the policy, steers away from the exacting a punishment approach by saying that most often when considering immigration consequences, the immigration considered offer or sentencing recommendation will be commensurate with the original offer or recommendation. In other words, reaching an immigration neutral outcome in most circumstances without, having some sort of requirement of demanding that additional punishment. I'm not going to go over, in the interest of time, the additional examples in any detail, but New York County is another policy that we wanted to share with you. You can see here they're really emphasizing a holistic analysis, and again, that usually the offense level and sentence length would be the same as it would be for a citizen or non-citizen. All that the policy is doing is opening up in that holistic analysis to taking away that deportation consequence. The last one that's in the materials is the Santa Clara District Attorney's policy, which is one of the very first policies after the Padilla decision. And here you can see elements of this exacting a punishment approach of sort of requiring a harsher punishment as well, that I think more offices are in recent years are moving away from. So with that, I'll stop and turn it over to the questions.
Thank you so much to all our presenters. And I know we have a lot of questions in the chat. We won't be able to get to all of them. I'm going to skip my questions so that we can get directly into some of your questions. The first question that I'm going to take is open to anyone, but it's about the Lake and Riley Act, which is a bill that's is in front of the Senate. And there's a question about what are the chances that the Lake and Riley Act is passed without the amendments being made that will consider the rights of all individuals within the entire spectrum. This is a bill that's based on the killing of Lake and Riley in Georgia last year and imposes a lot of really harsh immigration consequences that are very illogical. A lot of presenters talk more about some of the harms of this bill. And the other part of the question is, if it is passed without proper amendments, what are the ramifications in your work as attorneys in this work? So anyone can take that if they'd like.
Sure. Or Linus, you want to take it, or I can?
I'll just really say, like, who knows? I don't know whether it will pass, depending on the amendments. I think one of the real difficult parts is, like, in Minnesota specifically, a lot of people get shoplifting citations. So Target and other big retailers are the ones that sign the citations and give it to them. So I'm not even sure how that would work, because then ICE would be obligated to know that a person's been cited and then fine them. And this is not even counting people who may not be in the system. So that's going to be a real, I just don't know how that's going to play out if that's the way the language of the statute is. I think clearly the difficulty here is we are introducing more ways in which convictions do not matter, and we're introducing more ways in which mandatory detention would be required.
Yes, sorry, I should have clarified. It's a bill that applies to shoplifting offenses and creates a mandatory detention requirement, even just for an arrest, without anything beyond that. But Talia, I'll turn it over to you.
Yeah, just to add a little bit to that. Yeah, so it's specifically geared towards undocumented individuals who, like, others have said, are arrested for or sort of admit kind of engaging in this broad theft offense language that we talked about. And again, it really is honing in on detention and creating this. There are many people detained in the United States, but it's sort of seeking to really expand the criminalization and jailing of individuals on allegations alone. So again, we showed you the ways in which the system has sort of evolved that way. It's taking it further. And I think there's even been concern raised by ICE itself, who's saying this sort of would lead to us being required to detain certain individuals charged on petty shoplifting offenses that are later dismissed. Even in that instance, right, this would apply, and perhaps have to release other individuals. So it's there's concerns on all sides, I would say, and it would be very difficult to administer. And in terms of, so I think it would obviously create more individuals in detention. So I do work representing people detained, as does Linus and others here. And it's also obviously much more difficult to litigate when someone's detained, access to counsel, access to witnesses, very, very complicated. But also, I think it would make your work really difficult as prosecutors, where this is sort of talking about putting people in immigration detention based solely on charges or an arrest. So I think like resolving matters would become more difficult on these kinds of offenses and would create a lot of issues for local prosecutors as well. So it's very disturbing and damaging in a lot of ways. That would give state attorneys general additional powers to sort of sue in circumstances the federal government. So very, very concerning and overly broad. And again, I can't speak to whether it'll pass, but very concerning.
Thank you. And Ingrid, I see that you've sort of answered the next question I was going to ask in the chat. So I'll give you an opportunity to just quickly address it to everyone. If a prosecutor does not think a defense attorney has properly informed their client of Padilla requirements, how should they proceed? And I know you linked to an article that we'll link to as well.
Because I don't know if anyone wants to jump in. I mean, I think what I was trying to start to address in the chat is that this is a really important issue. I mean, I clearly, a plea cannot go forward without having that kind of advisal. The prosecutor, it's not the prosecutor's role to give that advice, but talking to defense counsel, agreeing to additional time for continuance, for example, for the sentencing, so that. I mean, for the change of plea so that advisal can take place. And I think sort of more institutional issues about trying to really enhance the quality of defense counsel, having trainings, perhaps there could be a joint training across prosecution and defense offices, or sort of like what we're doing today on these issues. Although a lot of sort of newer defense counsel are, going to trainings and getting the information that they need to provide that kind of advisal. This is still a topic, as I talk about in the article that I shared, that is an area where there is a lot more work to be done. So it's amazing that you're noticing that and seeing that and calling attention to it. And so if you can do some of that institutional work to make the system stronger in your jurisdiction, that would just be really wonderful. The Immigrant Legal Resource Center, ILRC, I know one person asked about, is there any sort of pre-made forms or anything? They have incredible resources. Some of it's focused on California, but a lot of it is national. So the more you can get ILRC materials into the hands of defense counsel, even getting them to consult with them on cases or consult with an immigrant rights group that has that kind of expertise in your jurisdiction, that can be really powerful for defense counsel to rely on as well.
Thank you so much. Another question we got was asking about requiring defendants to stipulate to probable cause for the charge in exchange for dismissal. Is that considered an admission of guilt?
Well, remember, it requires two things. One, it requires admission of sufficient facts for the elements of the offense. So if they are explicitly talking about the facts that they have committed the crime rather than there might be probable cause for the crime, I think that could be enough, depending on how exactly it would be. But it would also require some form of penalty and punishment imposed after that. I'm not sure exactly. I think it would have to be very specific. The requirements of admission under both the 212 requirements are relatively stringent. So you can't just say, I'm guilty of something. That requires some aspect of the different elements of the criminal statute. I don't know if anyone else has any thoughts on that.
I think we have time for one more, which is how can declinations to prosecute or dismissal case outcomes impact non-citizens when there's an admission of facts? So similar question.
And I think one thing, we haven't, had time to get into, but there are certain conduct bars, and conduct that can lead to someone being deported from this country. So sometimes admissions to conduct could also have immigration consequences. So that's something that defense counsel would also need to advise on. And if they have an expert in their office, I think being able to rely on that person and have them, explain what the consequence would be, could be a really helpful way to, consider if that would be a good option in your jurisdiction.
Specifically, like reason to believe a drug trafficker is one that doesn't require a conviction. But again, in terms of a conviction, that would go back to the definition under 101-848.
Okay, I lied. I have one more question that just came in that I'm gonna take if we have just a second, because it's about resources. And someone's asking, are there any resources that a prosecutor can contact in order to determine if a plea is immigration safe? Oftentimes the prosecutor's office will say that a plea is immigration safe, but the defense attorney states that they conferenced with an immigration attorney who stated that the plea was not immigration safe.
I would just say, some prosecutors' offices have hired someone to, be an internal expert. Talia, do you want to talk about that, please?
Are you sure? I can go after you. You sure? Oh, yeah. So this is really complicated. I know it's really hard, and I really appreciate the questions of people wanting to provide like accurate advice and understanding that. But again, yeah. So I guess to the point that Ingrid was raising, I think, and I people have hired internal immigration attorneys, but I don't think the role of that individual is to assess in every single case sort of what are the ramifications, and that's for a lot of reasons, right? No, asking the immigration status of a defendant for multiple reasons as a prosecutor, I would say is inappropriate. I mean, certainly on the record, there's many concerns, but also as we talked about here, these analyses are extremely complex. So you really need to, and I worked as a Padilla attorney, which is what we called it, post Padilla, for 4 years here in New York. And there's so much that needs to be understood as to the immigrant's specific history that could impact their eligibility for defenses, their pathways, including talking to family members. It's extremely detailed. And I just don't think it's the appropriate role of the prosecutor to do that. That's also not, you're not representing the defendant, right? You're representing the people. It's a very different obligation. Where I think this adequate advice that Ingrid is speaking about, that Padilla really requires, and certain states have codified, it's a totally different analysis. And I don't think the prosecutor themselves it's just not appropriate to engage in that specific sort of questioning whether or not really for this non-citizen this will lead to X, Y, or Z. And I know it's hard. It's sort of like deferring to the judgment of the immigration expert, but it's also is sort of this like part of the representation and that effective representation and that kind of sacred relationship, right, as a representative. So I feel, it's difficult. But I do think we've talked about here just in general, there are some ways to resolve cases. We can't give you a blanket list. And I know everyone wants that of like, this is safe in every case, but there are some things that you heard, Linus talking about Minnesota specific. Here in New York, we have specific materials in California of general like sort of guidelines about the kinds of offenses that may not trigger consequences. So I think there's things out there. So I'll say to materials, the Immigrant Defense Project has some materials New York specific. You heard about California, and I know a lot of other jurisdictions have materials that talk about at least giving you some point of reference. So to the extent that there are offenses that might be kind of safer resolutions, I don't even want to say that because it's not true across the board. You could engage, if you're concerned in a specific case, I think you could, try to resolve it with something that likely would not carry immigration consequences, but might meet your other goals and objectives in the prosecution. So I think that that's all really permissive and within the realm of what prosecutors do all the time in considering individual circumstances and trying to sort of mitigate in that circumstance. So it's very hard. And I do think having immigration knowledge in the prosecutor's office is important, and having someone who can look into the constant changing state of law. But I don't know that doing an individual analysis in every case, I don't think that that's the appropriate role. And my article talks a little bit more about that, and happy to talk about it more with anyone offline.
Wonderful. Well, we really appreciate all the expertise from each of our panelists today. And I'm sorry we went a little over time and didn't get to all of the questions, but that's because there were so many and such informative information. And as I mentioned, the IIP will continue to be very engaged on this issue. And we will continue to advise prosecutors on how you can best serve immigrant communities. But I really want to thank our esteemed professors for joining us today and sharing their wisdom with all of you. So thank you so much. And we'll be here again soon for our next webinar. Thanks so much.